Hi, I'm Daniel. I'm a Senior Associate and Trademark Attorney at Osborne Clarke. I'm joined today by my colleague Ethan, who's an associate in our IP team as well. Today we're going to be talking about some interesting lookalikes cases and some of the judgments that have come out of those. So Ethan, to kick us off, I think the Tesco litigation is probably the most well known in this area that concerned Tesco's club card branding. Can you tell us a little bit about why that was so interesting?
Sure. So this was a case that Lidl brought against Tesco for trademark infringement, arguing that Tesco's club card prices logo infringed Lidl's registered trademarks protecting its own logo. So the interesting thing in this case is that rather than relying on a likelihood of confusion, Lidl claimed that the similarity between the two sets of marks created a perception in the mind of the average consumer that Tesco was price matching its own products to that of Lidl's, which therefore took unfair advantage of Lidl's reputation as a low-cost provider. That being said, this was very fact-specific, and Lidl's success also relied on evidence from consumers, from surveys, and also some evidence from Tesco's internal documents, which showed that Tesco had ignored its own warnings as to the similarities between that of its mark and Lidl's. So it is debatable whether this success would be repeated in other cases, but it is likely that the approach Lidl took could be used as a blueprint for attacking lookalike brands in the future.
And what about your more traditional lookalike case, where an original manufacturer is trying to stop someone from putting a competing lookalike on the market? Have there been any interesting cases like that in recent years?
Yes, so we also saw a claim brought by Thatchers against Aldi in connection with Aldi's sale of a lookalike cloudy cider lemon drink, which used packaging which Thatchers alleged infringed its trademark rights, protecting its own cloudy lemon cider drink. Aldi admitted in this case that it had benchmarked its own product against that of Thatchers, and despite instructing its designers to add whole lemons so as to make a hybrid of Thatchers and Aldi's ranges, it successfully avoided infringement. One of the key issues that Thatchers faced here is that its own trademark only covered its 2D getup of its product, whereas the Aldi infringing sign was a 3D can, and these were held to have a low degree of similarity. Thatchers also struggled to show a likelihood of confusion, which is quite common in these kind of cases, in which a supermarket deliberately benchmarks against a branded product, but then designs away from this product so as to avoid trademark infringement. So it does mean that it can be quite tricky for brand owners to enforce against lookalikes in cases such as these. However, I would query whether Thatchers would have had more success had their product been covered by a registered design instead of a trademark. Now, Daniel, I understand that there's been a few cases where this has been successful.
Yeah, so this year saw the Court of Appeal decision in the Marks and Spencers and Aldi litigation. So originally, Marks and Spencer sued Aldi for copying what is effectively their gin liqueur product. Marks and Spencer's put out a Christmas-themed gin, which had gold leaf inside and an LED light-up bottle that looked a bit like a snow globe. Aldi came along and created a competing product, so Marks and Spencer sued them. Now, Marks and Spencer's luckily registered some designs to protect the design of their bottle, and the court at first instance found that it was design infringement. So their view was that Aldi's products gave off the same overall impression as Marks and Spencer's original products. Now this year the Court of Appeal upheld that, so they decided that it was design infringement, but they also added some quite interesting comments about design law generally that those interested in the area should definitely read. I think the key takeaway from this case is that this was really Marks and Spencer's only avenue to attack Aldi's lookalike product. Aldi's products didn't have the trademarks on, so a trademark infringement or passing off action wouldn't have worked for them. And I think it therefore highlights just how powerful a tool designs can be in the fight against lookalikes. On a more technical note, it's also worth bearing in mind that it's slightly easier to make out a test for design infringement as compared to trademark infringement. Now, the reason for that is that under design law, the informed user is deemed to be slightly more observant than the average consumer under trademark law. So it can be an easier case to make when trying to bring proceedings against lookalikes. So Businesses should really bear that in mind and think about whether design protection is appropriate for their product, in particular where it's a novel product like Marks and Spencer's.
Thanks, Daniel.
Thanks everyone for tuning in. There's definitely been some interesting cases over the last few years, and businesses should certainly pay attention in particular after the controversial Tesco decision.